Hello students, welcome in the class. Before going on our today topic, just recall our previous lecture. In previous lecture, we learned about cyber jurisprudence, that is study of laws which is directly related to cyber crimes. Then cyber jurisprudence at Indian level, in which there are two main acts: Information Technology Act 2000, Information Technology Amendment Act 2008. Information Technology Act 2008 amend 4 acts. First one is Indian Penal Code, that works on paper-based evidence, but after IT Act 2000, it also include electronic documents. Then Indian Evidence Act, Banker Books, and Reserve Bank of India Act. These 4 acts deal with paper-based work, but after the evaluation of IT, after passing of IT Act 2000, these 4 acts can deal with electronic documents. We can say electronic communication. So IT Act Amendment 2008, it just amend our IT Act 2000. And the another act at Indian level was Prevention of Money Laundering Act 2002. That is amended in year 2005, 2009, 2012. So after the Indian law, we discussed about international level. In previous lecture, we learned about Health Insurance Portability and Accountability Act, that deal with the information of patient that cannot be shared among any organization, any person without patient permission. Then Sarbanes-Oxley Act, that deal with financial corporation. Cable Communication Policy Act, that deal with the broadcasting of events on communication over telephone, radio, cable, etc. Then Children Internet Protection Act, under which act children assess blocked to assess or view any harmful content. Children Online Privacy Protection Act, in which children information can be shared under control of their parents. So we discussed about first 5 Cyber Jurisprudence Act at international level. So in this lecture, we will continue remaining international level acts. So the first act in this lecture is CISA, Cyber Security Information Sharing Act. Let us understand about it. What is the purpose of CISA? The bill was introduced in US stand on July 10, 2014 and passed in Senate October 27, 2015. Cybersecurity Information Sharing Act submitted in US court in 2014 and passed by Parliament in 2015. What is the main purpose of Cybersecurity Information Sharing Act, known as CISA? National efforts to understand, manage, and reduce risk to our cyber and physical infrastructure. So it helps to minimize cyber risk and physical infrastructure at national level. The next act is Cyber Enhancement Act of 2014, an act to provide for an ongoing voluntary public-private partnership to improve cybersecurity and to strengthen cybersecurity research and development, workforce development and education, and public awareness for other purpose. So Cyber Enhancement Act, it enhance cybersecurity, public-private partnership. What is mean by public-private partnership? For example, you buy any product from Amazon, so you are public, and the Amazon is a private. So public-private partnership. We deal over internet, means we buy something and pay online. So this is public-private partnership. This is a short example. It can be in at a complex example can be partnership between organizations, enterprises. So it improve partnership between public and private over cyber. We can say in cyberspace. Federal Exchange Data Breach Notification Act of 2015. It passed in 2015, and the main aim of this act is to enhance data security by ensuring that individual and law enforcement are notified when sensitive personal information is put at risk, and by creating incentive for entities to take steps to secure their data systems. Let us understand about this act with help of an example. For example, you sign in your email account at somewhere and you receive a notification. Nowadays, you receive a notification that your account is logged on some system, and there are option you can take an action. Means if you are not, then system will report the login. Means that system, if somebody try to sign in your email from any system, and if you click that you are not login, you are not try to log in, then it will automatically log out from that system. So Notification Act aim, when sensitive personal information is put at risk, the notification will give to the individual or organization. National Cyber Security Protection Advancement Act of 2015 to amend the Homeland Security Act of 2002. So National Cyber Security Protection Advancement Act, it adds some feature to Homeland Security Act. Homeland Security Act passed in 2002, and 2015 it amended and known as National Cyber Security Protection Advancement Act. What is the main purpose of this act is to make certain improvements regarding cybersecurity and critical infrastructure protection, and for other purpose. So it also improve cybersecurity. So now what is the mean of critical infrastructure protection? Infrastructure, we can say memory, server. So this act emphasizes on infrastructure protection. For example, you post a picture on Facebook and you delete it from your phone. But when you open your image in Facebook, it also there, although you delete it from your device. So now question is where your image is stored. Your image is stored at Facebook space, cloud space we can say. As we know, cloud provide us memory, server, software, platform, etc. So our image is stored at Facebook backend. We can say Facebook storage, memory. So memory also require protection. This is only image. There can be your sensitive information like your account information, your net banking ID and password. So infrastructure protection is required. So this act improve cybersecurity and also infrastructure protection. So your information cannot be hacked by any hacker easily. So these are international level cyber jurisprudence act that is in USA. So now there are main three act I added in this PPT, that is in UK Data Protection Act 2018, Copyright Design and Patent Act 1988, the Absence Publication Act 1959. There are a number of acts in different countries. You can also search about that. You can also see the purpose of that acts. So in UK, the first one act is Data Protection Act 2018. Data Protection Act 2018. Firstly, what is the main purpose of Data Protection Act? What is the aim of Data Protection Act is control how your personal information is used by organizations, businesses, or the government. For example, our bank account. So our login ID and password of net banking is stored at bank. So now bank can log in by using ID and password and can transfer our amount. We can say fraud our money. So this act set some rules how your personal information is used by organization. Means bank can't access your assets, we can say property, we can say your money. So Data Protection Act control how your personal information is used by organization, business or government. For example, if bank login and transfer your amount in their account, you can take action against bank. Data Protection Act 2018 is the UK implementation of General Data Protection Regulation. They must make sure that information is used fairly, lawfully, and transparently. Again, our login ID and password stored at bank site, but it's fair. Only we can use our assets. But if they try to use our money, that is unfair, and we can take action against them with the help of cyber laws. The next one is Copyright Design and Patent Act 2088. The Copyright Design and Patent Act 2018 is current UK copyright law. In India, also copyright law, but in UK, this law that is passed in 1988 is also working in current mode. Recently, copyright law of UK is Copyright Design and Patent Act. So now let us see what is the main purpose of this act. It gives the creator of literacy, dramatic, musical, and artistic work the right to control the way in which their material may be used. Let us understand about this act with help of an example. For example, a singer upload their song. You all use YouTube, and if try to upload some video without permission of creator, they can report you and YouTube will delete that video. That is comes under this act. So creator will decide in which way material may be used. Creator can decide who can share their content, who can use their content. So Copyright Design and Patent Act helps the creator to decide to control their content, their material. Absence Publication Act 1959. What is the main purpose of this act is? It's related to the publication of absence matter to provide for the protection of literature and to strengthen the law concerning pornography. Absence matter. For example, I'm post some content on Facebook and it hit some culture. We can say I'm saying something wrong about any community. It comes under absence material. So this act control publication of absence material. If somebody try to publish absence matter, then an action can be taken against them. We see in our today life, our daily life, some person try to edit your religion pictures and post on social media. People report them and after few days their account is deleted. So that is possible with the help of absence publication act. Means if the material hit somebody, hit some community, religion, we can say some any culture, the action will be taken against the publication. So this is all about cyber jurisprudence at Indian level and at international level. So our next topic is jurisdiction in cyberspace. What is the meaning of jurisdiction? Firstly, we will see authority of a court to listen to a case. Authority can listen case and resolve a dispute involving person, property, and subject matter. These principles of jurisdiction are enshrined within the constitution of state and part of its jurisdictional sovereignty. So jurisdiction means a court who can listen a case and can decide a decision. So a court can listen case and take a decision against a person, property, or subject. Types of jurisdiction. Mainly three types of jurisdiction: personal jurisdiction, subject matter jurisdiction, pecuniary jurisdiction. The first one is personal jurisdiction. It is related with the person. It is the type of jurisdiction where the court can pass judgment on particular parties and person. And state jurisdiction is related to state. So for example, an accident occur in state. Both person from same state, same forum, it's okay. But if somebody is non-resident, means both are from different states, then there is no direct jurisdiction. This problem is solved by minimum contact theory, in which jurisdiction can solve problems over non-residents as well. The next one is subject matter jurisdiction. It is a type of jurisdiction where the court can hear and decide specific cases that include a particular subject matter. If a specific subject matter is one court, but the plaintiff had sued in any other court, then the plea will be rejected and the plaintiff will have to file the case in court which is related to the matter. So now any case will be submitted to the corresponding jurisdiction, we can say, court we can say. So the any case will be submitted to appropriate court, and if somebody submit their case in other court, their case will be rejected and he or she have to file the case in appropriate court. For example, environment related case will be filed in NGT, and if you try to file your case in district court, it will be rejected, and then again you have to file the case in NGT. If you try to file the case in other courts, it always rejected. It will be accepted only in NGT. Then the pecuniary jurisdiction. This type of jurisdiction mainly deals with monetary matters. The value of suit should not exceed the pecuniary jurisdiction. There are various limits set for a court that can try a case of certain value, beyond which it is tried in different courts. So this type of jurisdiction deal with money, and there is a limit. According to limit, you have to file your case to appropriate court. For example, district consumer can handle less than 20 lakh rupees. And if your amount is more than 20 lakh, you have to file your case to state consumer. And state consumer limit is more than 20 lakh but less than 1 crore. If limit is exceed 1 crore, then you have to file your case in national consumer. So there is a section according to the limit of money. So now issue of jurisdiction in cyberspace. These types of jurisdiction that works in traditional system, we can say physical world, but now in cyber, there are some issues. As we know, jurisdiction have power to hear a case and declare judgment. But both parties must be resident of that state. But as we know, in cyberspace, there is no boundary. Person can be even from different countries. In cybercrime, if the victim and accused both are from same country, then there is no problem. It's okay, it will work. But if both victim and accused are from different countries, then there is conflict to decide which jurisdiction will take decision, because internet has no boundaries, so no specific jurisdiction can be titled over its use, because a user is free to access whatever he wishes to and from wherever he wishes to, till the time user online activity is legal and not volatile of any law. Till then there is no issue. If all user in cyberspace do all work, all activities legally, then there is no problem, there is no issue. But it becomes illegal when criminal activities occur. So jurisdiction have to play a role. Let us discuss about one issue of jurisdiction in cyberspace with help of an example. For example, a person who commit robbery in country A, he is sitting in country B and using the server of country C. So now which country jurisdiction will decide, will take a decision? Because in this case, transaction might have been done virtually. People are present physically in respective countries and governed by their law. The court generally decide jurisdiction of country where crime has actually committed. In cyberspace, if both three parties, the person who commit crime, the person who is victim, and the server host, these are the three parties. If these are in same country, then that's okay. Jurisdiction will be work. But if three parties are from different countries, then there is a issue. We can't decide which country jurisdiction will take action. So there are some theories that helps to solve this problem. The first one is minimum contact theory. This test is applicable where both or any of one parties is both victim and criminal, and anyone, either it can be criminal or either it can be victim, are outside the territory jurisdiction of the court. After this case, the court let down three criteria. For example, both parties are from the different territories. Jurisdiction will listen their issue and decide some action. But after the case, the court have to let down three criteria. They have to check the non-resident defendant must do some act or communicate some transaction with the firm or perform some act by which he purposefully avail himself of privilege of conducting activities in form, thereby invoking the benefits on protection. The court will check defendant do some act. The claim must be one which arises out of or result from the defendant forum related activities. There are some activities that is related to form. Exercise of jurisdiction must be reasonable. It must be have a valid reason. So in short, court will see either this exercise is reasonable. For example, an accident is taken place, but car is hit by tree. So this is not reasonable. Another example, for example, car hit with another car. It is reasonable because activity is performed. Loss of property, we can say loss of persons is there. So it must be reasonable. And another one, non-resident defendant, either victim, either criminal, linked with some activities that is related to form. We can state, area, it must be related to the form, state or area. Then sliding scale theory. This is also known as JIPO test, and it deal with interactive website. There is no jurisdiction for passive websites. On the basis of interactivity of website, jurisdiction is decided. So now, firstly, see what is the passive websites, what is the interactive websites. A passive website is a website that makes information available to the user but doesn't permit any interaction like an advertisement. A website in which you can't interact with use website. For example, advertisement. You can see either they mention their phone number and email. You can contact with them, but these are passive website. You can't click on advertisement and can interact with them. Interactive website. active website where business transaction can occur through website or information can be exchanged to the business. For example, Flipkart, you buy anything and you make a payment. So now transaction occur place. So these are interactive websites. An interactive website is essentially an internet page that use different kind of software to create a rich, interactive and experience for user. It facilitates the user to be actively engaged with the site. For example, let's take the case of a website that displays weather forecasting for a specific reason. If the website is interactive, it enables the user to type in his or her location and shows the detailed weather report for that reason. The website may also display the weather forecast for various countries across the globe and allow the user to zoom and focus on specific reason. So in interactive website, there are exchange of information. There is some transactions will take place. So in passive website, you can't interact with the website. You just see the information, you just read the information, but you can't interact with the passive websites. The third theory is effect test and international targeting. Few conditions are required to be satisfied for the effect test. Mainly the action taken expressly against the forum state with the knowledge and intention that it will be injure the state. If court thinks fit that defendant action caused injuries to the forum state, then personal jurisdiction is asserted in cyberspace cases where no contact is present. Let us see example. In landmark case of Cadell v. Jones, the Supreme Court of US observed that court in state can exercise personal jurisdiction on non-residents. In this case, editor and writer of national magazine published a defamatory article on residents. The fact of case was that native Shirley Jones sued the distributor, the writer, and its editor Calder of the national magazine, defaming her as an alcoholic. Johannes was a resident of California, where the article was written and edited in Florida. Jones sued the defendant in court of California because magazine had a vast circulation in the state. The court held the court of California has personal jurisdiction over defendants. A editor write and edit a national magazine that published in California, and it hit the John, that is the citizen of other reason. The article edited in Florida but published in California, in which statement is Johan is a alcoholic. So now Johan file a case in California because magazine is circulate in California. So now California has a personal jurisdiction. So the magazine content affect the Johan, and Johan can file a court in California.